This lecture is on the Texas Judiciary. The learning objectives are to outline the structure and functions of the Texas court, to describe the function of each of the trial courts, to describe the function of the appellate courts in Texas, to evaluate the quality of justice in Texas, identify problems associated with different methods of judicial selection, analyze changes in the court's demographics, and to evaluate proposals for reforming the selection of the judiciary. What is the role of the court? First is to interpret the law. Interpret Texas law from the Constitution for minor criminal offenses. These laws must protect the interests of Texans as citizens and must be fairly and objectively applied. Initially, our courts were established by Mexico. The Texas Constitution and the legislature, when divided our court system, divided our court system into many levels of courts for local access, as well as appeals court system. Now, the Texas judicial system has the greatest number of courts in the nation. The courts should be as fair and impartial as possible when trying to interpret the laws of Texas. Dispensing justice. Post-Reconstruction Texans had a strong distrust of central government, and so created a court system with several levels that made it easier to appeal. Today, Texas has more courts than in any other state. The Texas court system is hierarchical from the bottom up. This means cases start at the lowest level and funnel up through courts as appropriate. This allows higher courts to review or check for bad decisions or incorrect rulings at lower level courts. Jurisdictions is the territory and types of cases over which a court exercises the authority. The Texas legislature sets the jurisdiction for courts, which determines what cases they hear. Trial courts have original jurisdiction and hear cases first. Higher courts have appellate jurisdiction. They examine cases from lower courts and in many instances choose the cases they wish to hear. Most courts hear both criminal and civil cases. Criminal can be classified as misdemeanors, such as using a false ID to buy alcohol, or felony, which would be a more serious crime, such as armed robbery or murder. The government charges the defendant. In civil cases, this is a dispute between two litigants. Not all courts hear all types of criminal and civil cases. Trial courts are divided based on whether they hear misdemeanors, lower crimes, or felonies, serious crimes. In this graphic, you see that Texas actually has 2,712 lower courts. The role of the court continued. We're going to talk about interpreting the law. A felony is the highest criminal offense under state or federal law. Misdemeanors are minor wrongdoings. Common law is those laws which are established when judges apply past decisions by courts or legal precedents to the facts of a new case before them. These are normative circumstances or established norms. If a law is vague or unclear or maybe even unconstitutional, the Texas Supreme Court is the final decision maker. Often their rulings have real-world consequences. When groups or individuals feel that a law passed by the legislature is unconstitutional, they can challenge it in the court. The court will make the decision whether to uphold it or not. If state interests clash with businesses or citizen interests, the court often sorts out the competing claims. Courts sort out claims of competing interests, for example, the state versus a business. In the 1800s, there was a dispute over land rights between the state and cattle ranchers, and the state ultimately won the battle in court. Advancing rule of the people. They were voted in so they could be voted out. Because Texas judges are elected by the people, they can be replaced if the public does not agree with their rulings. For example, in the late 20th century, many liberal Democratic judges were replaced by conservative Republican judges that better reflected the values of the electorate. Local courts are created by the Texas legislature and have most cases. They have original and exclusive jurisdiction over violations of city ordinances and Class C misdemeanors. There are many local courts. Houston has 28. Justice courts. These courts handle civil cases of $10,000 or less and crimes that are punishable only by fines. Combined, these courts handle 2.5 million cases, although the vast majority of them are uncontested. These courts generate revenue for the state. They actually collected $300 million in 2017. Constitutional county courts. These don't usually deal with legal materials. They oversee the commissioner's court, has authority over county government operations, and has budgetary authority. County courts at law. These hear civil matters between $200 and $200,000. They have appellate jurisdiction and can hear appeals from local trial courts. Probate courts. Probate is a process to determine the validity of one's will. Probate courts are only in large metropolitan areas. Otherwise, people just use their county or district court. State district courts. These courts handle serious crimes, mostly drug offenses, and civil cases without limit. 40% of their cases are family related. 31% are criminal. In these cases, the defendant can decide whether they want the judges to decide the cases, which is a bench trial, or a jury trial. 21% of the cases are civil, and the rest are juvenile or other. More than half of all criminal cases result in convictions, but only about half of all cases of any type actually go to trial. Appellate courts. They do not hold trials, but review legal issues of cases from lower courts. So a petitioner files for an appeal, and then they submit a written argument, which is called a brief. The justice in the courts might decide based on the brief, or they may want to hear oral arguments where attorneys present their cases in person. Outsiders or friends of the court with an interest in any case may want to have a say. Judges issue an opinion document, which is typically the majority opinion. Often there is disagreement on ideological or legal matters. If the appellate court affirms the lower court's judgment, the case ends. If the lower court judgment is reversed, the higher court can send the case back to the lower court for additional action, such as a new trial. Intermediate appellate courts. These are the lowest level of appeals courts. These courts are separated into 14 districts across the state. They review less than 10% of cases, but many of these cases are mandatory reviews of criminal cases, except in the case of a death penalty case. Usually 3 justices will decide the case by majority vote. Caseload. An average judge's caseload can be a key indicator of justice. The more cases a judge has to handle, the more likely he or she is to make mistakes. There are 3,200 judges in Texas, and they dispose of over 8 million cases in 2016. Courts are becoming more efficient in dealing with their cases, and there are fewer cases being appealed to the highest courts, making for easier caseloads. In length of cases, there is a saying that justice delayed is justice denied. Thankfully, courts in Texas are handling cases more quickly than they have in the past. Are judges underpaid? Judges in Texas are paid more than they have been in the past, but Texas still lags behind many states in judicial compensation. Because judges can usually make more in the private sector, some of them leave. Turnover of judges. Despite the appeal of the private sector, most judges stay in their position for a multitude of reasons. Stability and experience enables judges to handle cases more quickly. And when judges do leave, the most commonly cited reasons are the election process and the salary. It should be noted that wealthier individuals and groups have easier access to justice. Lower income Texans have the opportunity for government-sponsored legal aid. But of the 5.6 million Texans who qualified for legal aid, just 100,000 cases were handled in 2016. The legislature spent almost $17 million on legal aid in 2015. So, how are judges selected? Some states have the governor or the legislature select their judges. Other states use merit selection. Research indicates that merit selection decreases partisanship and increases diversity on the bench. Texans use elections to select their judges. This emphasizes popular control. States that want to emphasize judicial independence use the appointment process or merit selection. Texas has used many methods of judicial selection. Today, all judges in Texas are chosen in partisan elections. The governor does have the opportunity to fill unexpected vacancies, but such appointed judges must run in the next election. Appellate court judges are elected to 6-year terms. Trial court judges are elected to 4-year terms. Judicial campaigns in Texas are influenced by the Texas Code of Judicial Conduct. This code recommends that judges refrain from inappropriate political activity. Judges are prohibited from making pledges about pending cases. Judges who violate the rule face sanctions, fines, and possible disbarment. Censure and removal from office. Judges who violate the standards of conduct face discipline, censure, or removal from office. They can be removed by the State Commission on Judicial Conduct, by the Texas Supreme Court, or through impeachment by the legislature. Judicial qualifications. Cities set the standards for their municipal court judges. Justice of the peace and constitutional county court judges are not required to have law degrees. Of course, many of the duties of county judge are not legal in nature. District court judges are required to have at least 4 years of legal experience. For appellate court judges, the standard is 10 years of legal experience. In addition, they have a minimum age of 35, and they are forced to retire when they turn 74. Problems with partisan elections. Because of the one-party dominance in Texas, the general election vote for judges tends to be one-sided, with the real fight occurring in the primaries. In the general election, most voters look for the appropriate label to guide their choice in judicial elections. Judicial races are seen by many voters as less important, likely because of a lack of media coverage and because they are at the end of the ballot. So as a result, many voters just skip it entirely. Because judicial elections are low information, many voters make their decisions on the basis of, do they recognize the name? For conflict of interest, donors might end up in somebody's court, and Republicans were able to use these concerns about conflict of interest to win 5 of 6 high court seats for election in 1988. In judicial elections in Texas, party is more important than experience. Most voters simply cast a straight ticket ballot, and this creates interesting results. In 2010, all Bexar County judges elected were Republicans, and in 2012, they all were Democrats. Interest groups donate millions of dollars to judicial races because of what is at stake in these court cases. Trial judges tend to give longer sentences closer to re-election time to indicate that they're tough on crime. So what are the justices? Elected officials should be a reflection of their constituents. Since Texas has greater diversity, the Texas judgeships should also be diverse for citizen trust and connection with their concerns. Politicians, civil rights organizations, and bar associations have pushed for increased diversity. Gubernatorial appointees have increased diversity on the bench. It also helps when there are concentrations of racial minorities in geographic areas, but their voting influence is limited to upper-level courts. The first woman was elected to the district court, and that did not come until 1935. Today, 38% of Texas judges are female, which puts Texas in the top 10 among all states. Women make up 36% of the state bar. In 2001, Governor Perry appointed the first African American Chief Justice in Texas, who was reelected in 2006. Today, African Americans make up about 4% of all judges and 5% of the state bar. The first Hispanic on the Texas Supreme Court was appointed by Governor Mark White in 1984. Today, Hispanics are 17% of all judges and 10% of the state bar. Asian Americans are less than 1% of all Texas judges and 3% of the state bar. They are severely underrepresented. Reforming the system. Nonpartisan elections. Some judges have endorsed the idea of keeping judicial elections, but removing the party label. Not surprisingly, this is highly opposed by the parties themselves. Another proposed idea is to set aside tax dollars to be used as the only funds that judicial candidates can spend in their elections. This was proposed in the 2015 legislative session, but went nowhere. In 1995, the Judicial Campaign Fairness Act limited individual donations to judicial elections. So the size of the limit depends on the court. Law firms are also limited in their donations. The state regulates these contributions. Sometimes merit selection, sometimes referred to as the Missouri Plan, this system has a group of experts select judges, and voters then determine whether they stay in office using retention elections. The reference for this lecture is Inside Texas Politics by Brendan Rottinghaus.